Ohio's had the opportunity to review the pre-sentence report
No, you haven't.
that was created, I guess.
There was no pre-sentence report.
I don't know what you would call it. There
Oh,
was-
just the criminal history.
Yeah. Whatever you want to call it. I reviewed that and is prepared to go forward today.
Thank you. Mr. Uranka or Mr. O'Connor, any reason not to go forward with sentencing?
No reason not to proceed.
No reason, Your Honor.
And Mr. Uranka, I'll start with you first. You have case 24 CR 967. Anything you'd like to say on behalf of your client?
I do, Your Honor. I did talk with Eric. I figure I'll start with the negatives. So he does understand just how poorly some of these probation or bond issues have gone for him at this time. So he does understand that there's going to be some consequences for his choices. Turning to the positives, Your Honor, he does report that the MAT program was something that was helpful to him. Certainly we wish that some other choices had been made. One of the positive things that he had talked about with me is his daughter, his oldest daughter, is enrolled at Ohio State. She's a cheerleader for the football team. So he is excited for her to have the opportunity to be with the football team later tonight. As it relates to the pre-sentence investigation, we were able to review what was prepared. I believe that was the history and the complaint and some of the other paperwork that probation prepared. I did ask him why he removed the GPS monitor. He's advised me that he learned of the warrant that was issued for his non-appearance with probation immediately after the sentencing, and that caused him to make some poor choices. I did ask him why he didn't appear for probation. He told me that he did contact probation and he was advised not to come until tomorrow after he had left to go get some food. They told him, come on in tomorrow. I did discuss with him why he didn't go in. He told me that he learned of the warrant and he was afraid at that point.
Well, why didn't he go right from here over there like he was told to by this court? Well, I guess you don't have to answer that.
I wish I had a good answer for that.
You're not in his head. Good.
His big concern right now, he does understand the situation he's put himself in. His hope is that his bad choices won't adversely affect his mom, who it's my understanding he recently began a relationship with, and she's posted a significant amount of money towards his bond. He's hopeful that she will not be out a sizable amount of money as a result of his poor choices. So for those reasons, Your Honor, we ask that the court take those into consideration in fashioning a sentence. Thank you.
Mr. O'Connor, as to case 24 CR 1174, anything you care to say on behalf of your client before sentencing?
Thank you, Your Honor. Your Honor, in regards to Mr. Ruskin, when I won't belabor some of the points Mr. Uranka already had mentioned. However, with Mr. Ruskin, when I first met with him in regards to this matter, back when it was still pending in the misdemeanor court, right away he recognized he wanted to take full responsibility for his actions and get this matter done as quickly as possible. There wasn't any question of whether or not to present any defenses or anything like that. He wanted to take full responsibility and address this case. He recognizes that he made some poor decisions, and I think when he gets a chance to speak, he'll not try to make any excuses and just recognize that when a court orders something, you got to follow through with it and make sure that you're in compliance. I know he wants to take advantage of the programming at prison and address some of his decision making so that he's in a position where when he does get out, that he's able to succeed. But we would just ask consideration for the fact that he wanted to take full responsibility on this from the beginning, and essentially we had him arraigned and then immediately set for change of plea on this matter. But I believe that he does show remorse for his actions, and we just ask that that be taken into consideration in regards to his sentence on this matter.
Thank you. Mr. Ruskin, you have the right to address this court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, sir.
What?
Do you want me to stand? Or?
You can do whatever you want to do.
Well, I've been coming to this seat in front of you for how many years? Finally got clean off of heroin, which is very hard to, very hard for me. I just I want to take full responsibility in all my actions that I accept everything I've done. I'm not making excuses for what I've done. I've done everything that I did. I did it. You know what I mean? And I just, over the years, I have a lot more of myself to work on. You know, I have a lot of stuff to do, work on myself, and I'm sorry. I apologize to the families that I used their credit cards and this and that. I don't know how that transpired in their life, how that hurt them.
Bad.
I
I could read you some of the victim impact statement which she had to go through because of what you did. She shouldn't have to deal with all that. She did nothing wrong.
No, she did not. And I just want to apologize for my actions, and I'm ready to take responsibility and just move forward from here on out.
Mr. Urankar, Mr. O'Connor, anything else you care to add, Mr. Urankar?
No.
Nothing else, Your Honor.
For the state of Ohio, Mr. Gagarich?
Thank you, Your Honor. The state of Ohio is asking for a prison term in this matter. We believe that anything less than actual incarceration will demean the seriousness of the offenses. And the offenses are serious each in their own way. In as much as the conveyance into the jail, this is brought to light due to the fact that an inmate ODs overdosed in the jail. We have people who are off drugs, were spending money on JTP, and yet those people are most vulnerable at that point in jail to overdose and die. And the individual's lucky that a guard happened to be able to take care of the situation. The court's also aware of the second case, the problems that were caused for the victim in this matter. In the state of Ohio, would ask the sentence to reflect that. Thank you.
Well, this court has considered the particular facts and circumstances and the nature of the offenses charged here. I do not have a pre-sentence report investigation, a complete report to consider because the defendant failed to go to the probation department to initially meet them at the referral for an interview so that they could prepare a full and complete pre-sentence report. I was provided with a criminal history, and that was in a summary of the offenses. That's not a complete pre-sentence report, so I did consider what was presented to the court. I've considered what's been said here today by Mr. Ruskin, Mr. Urankar, Mr. O'Connor. Consider the prosecutor's comments and recommendation. All of this is considered in light of the purposes and principles of felony sentencing, which are set forth in 29-2911 of the revised code. As for the factors in 29-2912, factors indicating the conduct is more or less serious, the court notes in 24 CR 967, the conveyance cases, that the defendant acted as a part of organized criminal activity, which makes the offense more serious. In 24 CR 1174, the court notes that the victim actually suffered not just economic harm, but a serious psychological harm. She's got a young child in the home, very, very concerned about someone breaking into the home now. I was very upset not only that it was on a property of our house where my 3-year-old son lives, but that this isn't the first time he's committed a crime like this. He drained out all my bank accounts, took keys to cars that are very expensive to replace, my wallet that had all my insurance cards, driver's license, car insurance cards that had to all be replaced. The inconvenience and the headaches that people have to go through when this stuff is done to them is a nightmare. Hell, it's a nightmare just to call your credit card company to find out information. You have to do all this with all these different companies because somebody decides that they're going to break into their car and steal items that aren't belonging to them. Aside from that, if they're going to therapy, they're terrified someone's coming to the house in the middle of the night, concerned that someone now may even enter the home. She shouldn't have to deal with all this stuff, but she has to. Because of what you did. Lived in her house for 24 years, never had to deal with this, and now she feels unsafe because of Eric Ruskin. So I've considered the victim impact statement as well. As for factors indicating it's less serious, there's nothing present indicating it's less serious. quite frankly, as for the conveyance charges, just the nature and the planning and the scheming to go about doing what they did makes it much more serious than normal. The normal conveyance charge we deal with is someone gets arrested, they have drugs in their shoe or their sock, and they don't tell the police officers they have it, and they go in. That's the normal charge. Not the planning and scheming that went into this by putting together discovery packets and sending in thumb drives with drugs inside of them, or fishing line going out a window, and having all these people involved in making these plans to get it in. The conduct involved in the conveyance charges is much more serious than the normal conveyance charge that we deal with. As for the recidivism factors, most of these are present as well. The defendant committed the offense while he was on post-release control. He's got a lengthy history going back, 22 years. 2002, I think, was the first conviction. Been before me multiple times. He's been sent to prison multiple occasions. He's not responded favorably in the past to previously imposed sanctions, has probation violations, has parole violations. I don't find genuine remorse in regards to this conduct. The defendant couldn't even go across the next door to get a pre-sentence report. He violated his bond and failing to, again, go get the pre-sentence report. And he was on GPS monitoring. He cut off the bracelet. These are all factors indicating recidivism is guaranteed, quite frankly. No factors indicate recidivism is less likely. Under 2913B1 for 24 CR 1174, the F5s, the court finds the defendant has previously served a prison term and committed the offense while on post-release control. Prison is consistent with the purposes and principles of sentencing in both of these cases, and the defendant is not amenable to any available community control sanctions. Therefore, will be the sentence of this court, case 24 CR 967, then count 1, defendant served a term in prison of 24 months. On count 5, that he served a term in prison of 24 months. Those two terms will be served consecutive to each other for 48 months in prison. In 24 CR 1174, sentence of this court that amended counts 1 and count 3, defendant served a term in prison of 11 months on each count. I'll run those concurrent with each other, but consecutive to the 48-month prison term imposed in 24-967 for an overall prison term of 4 years. Oh no, would that be 59 months? In case 24 CR 967, the defendant has credit for 53 days. This time overlaps, doesn't it? Or is there time separate and apart for each case?
It overlaps,
There's no credit on 24 CR 1174 since it's consecutive. In 24 CR 1174, I'm going to order restitution to Ms. Zidek, Hannah Zidek, Z-I-D-E-K, of $577. Both cases, defendants ordered to pay costs. Both of these cases, I need to advise you that upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. This court does disapprove of the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Or further finds that consecutive service is necessary in this case to protect the public from future crime and to punish the offender. Consecutive sentences that are imposed not just in 24 CR 967 with counts 1 and 5, but also between the two separate cases, are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And the court finds that he committed all of these offenses while he was on post-release control, and that his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. I will release bond that was posted in each case. The remaining counts of each indictment are dismissed. Mr. Geigers, is there anything I'm missing here or forgetting or should I have to address?
Don't think so, Your Honor. The only thing that might be would be forfeiture of anything that was seized by law enforcement.
I don't know what was seized by law enforcement. I'm not worried about that.
A defendant stands for sentencing after years of violations, drug smuggling plans, and a victim impact statement describing fear and financial loss. The judge rejects excuses, cites his long criminal record, and drops a 4-year prison term.